In September 1993, two rival media empires fought for control of the historic Paramount studio. Sumner Redstone controlled Viacom. He called his deal a marriage that no nuclear attack could break. Barry Diller led the televised shopping company QVC. He arrived uninvited. He offered Paramount shareholders more money. Redstone backed Viacom with co-investors like Blockbuster. Diller backed QVC with telephone and cable companies. Redstone claimed his transaction was immune to outside bids. That claim directly challenged the voting rights of Paramount stockholders. Paramount originally agreed to merge with Viacom. The board accepted a package of Viacom stock and cash. The Paramount directors granted Viacom 3 defensive provisions to deter competing bids. First, a no-shop restricted negotiations. Second, a $100 million termination fee. Third, an uncapped stock option allowed Viacom to pay with a note or demand the cash difference. The board cemented their preferred deal with Redstone. They built a fortress against competing offers without considering the vulnerability of their public stockholders. Diller refused to walk away. In late October, QVC launched a hostile tender offer. This chart tracks the rising stakes. QVC attacked the Viacom deal with roughly $80 per share. Viacom raised to $85. QVC immediately answered with $90. The face value gap between the competing offers grew to exceed $1 billion. The rising bids triggered a severe side effect. The uncapped stock option rapidly swelled toward $500 million in value. The climbing prices weaponized the board's deterrents. The protective alliance became a massive financial penalty against Paramount stockholders. In October, the Paramount board amended the Viacom deal. They gained new negotiating leverage, yet they left all 3 defensive deterrents completely untouched. The directors used the no-shop provision as a contractual shield. They refused to negotiate with QVC. They refused to share information with Diller. The board relied on a flawed valuation method. They compared daily market prices of the competing bids. They ignored the actual future value stockholders would receive. The directors believed they were protected by a prior court decision involving Time and Warner. They mistakenly thought an auction duty required a literal corporate breakup. The board stayed loyal to a long-term strategic vision. A strategic vision does not justify ignoring $1 billion in immediate, measurable stockholder value. The Delaware Supreme Court intervened. The court subjected the Paramount board to enhanced judicial scrutiny. The court clarified the trigger. A literal breakup is not required. A sale or change of control forces a board to seek the highest value for stockholders. Paramount was owned by a fluid aggregation of public stockholders. The Viacom deal would transfer ownership to a single controlling entity. Public stockholders permanently lose their voting leverage once a single owner takes control. Therefore, the board must extract a control premium immediately. The court invalidated the defensive fortress. Corporate contracts like no-shop provisions and stock options cannot define or limit a director's fiduciary duties. Viacom ultimately acquired Paramount, but the court cemented a permanent limit on board power. During a sale of control, a board must act as a neutral auctioneer. The court closed its opinion with a highly unusual addendum. This final section focused entirely on professional conduct. In November, a lawyer for QVC traveled to Texas. He took the deposition of Paramount director J. Hugh Liedtke. Liedtke was defended by Texas attorney Joe Jamail. Jamail improperly directed the witness not to answer. He hurled vulgar insults like asshole. He told the opposing lawyer he could gag a maggot. He repeatedly threatened to shut the deposition down. The Delaware Supreme Court issued a stern reprimand. The court ruled that out-of-state lawyers participating in Delaware proceedings remain strictly bound by Delaware standards of civility. The dual rulings send a unified message. In the boardroom, directors cannot contract away their fiduciary duty. In the deposition room, lawyers cannot shout down professional integrity.